Good evening, everyone. I hope you are all are doing fine and staying home safe. So today's topic for the presentation and for today's session is Article 370 of the Indian Constitution, a brief history to revocation. So before I start sharing the screen, let me give you a brief introduction of the topic. See, the at the time of the partition of India in 1947, this partition was effected through the Lord Mountbatten Plan. And this Lord Mountbatten Plan, because earlier the Cripps Mission had come in 1952, bringing a proposal for setting up a constituent assembly for an independent India, which was not accepted by the Muslim League, because the Muslim League led by Muhammad Ali Jinnah wanted two separate nations of India and Pakistan, and wanted that a proposal should come for at least two constituent assemblies, one for India, the other for Pakistan. Then the Cripps mission failed because it was, majorly attacked by the Muslim League. Then the cabinet mission plan came in 1946, which was more or less agreed to upon by the Muslim League led by Muhammad Ali Jinnah, because it brought two proposals. So it also established certain, provisions for bringing new laws and for effecting the Lord Mountbatten Plan. Then Lord Mountbatten Plan came, and then came very last came the Indian Independence Act 1947 to give effect to the Lord Mountbatten Plan. So legally, the legal color was provided by the Indian Independence Act 1947. This Indian Independence Act 1947 had many provisions. Now, one of the provisions was that India and Pakistan, these two states were supposed to be divided. यानी कि पूरा जो India था, that was supposed to be divided into two nations, but into three territories. India, one side on the East Pakistan, the other side is the West Pakistan. East Pakistan, which is now Bangladesh, which became Bangladesh in 1971 after the Liberation War. So it later became, earlier it was Pakistan. So it was supposed to be divided into three territories and two nations, India and Pakistan. Now, talking about the princely states, Indian Independence Act 1947 had many provisions, and it gave, one of the provisions of the Indian Independence Act 1947 was that all the princely states. What were the princely states? Princely states was, let me explain you the political status of the princely states. The princely states, they had to, they were royal states, who, they were royal states like Jhansi, Satara, Jodhpur, Kashmir, Hyderabad, Mysore, and Junagadh, Jodhpur, and many more, many more. There were around 565 princely states together in India and Pakistan. And also, some write 543, some write, some write 560, 562, some write 540, 549. So there's a little difference in number. 565 total they were 565 princely states. Now these princely states were autonomous in their own region. They said to the British government that you let us rule within our boundaries. Okay, we have a well-defined boundary. We are confined within our boundaries, and let us be the ruler of our own dominion. Do not interfere in our local matters. Britishers said, okay, you will be given liberty to, become a Raja, to continue as Maharaja of your estate. But you will have to accept the suzerainty of the British government. And exactly that happened, that the princely states, they had to accept the suzerainty of the British government. They had to accept that they are sitting there inside their, inside their own confinements, and inside their own states, being a Raja. But there is somebody who is sitting above them, who can at any time interfere in their matters, can also legislate for some matters in their issues, can do anything. Like there was a typical kind of federal structure where the princely state was allowed to continue with its monarchical form of government, but at the same time had to accept the suzerainty or the superiority of the British government. British government used to legislate some national laws, which the princely states had to accept at their own local levels in their own states. So This was the issue, that princely states, they were allowed to continue as Raja and Maharaja in their own states. Okay, इसमें कोई problem हो तो बताइएगा. Princely states. Now, these princely states, they were given option in the Indian Independence Act. Apart from many other provisions, there was one provision that all the princely states were given three options. One was they were given the liberty to choose either to stay with India or to go with Pakistan or to become independent. So this third option was almost impractical. It was practically not feasible for the princely states to become independent, because already India and Pakistan had to start from the scratch. They were becoming a new nation. They were taking birth into a new country. So India was born like a new country in 1947, 15th August 1947, and it was difficult for India to cope up with all the laws that it had suffered so forth. Like up till now, the Britishers had been mindlessly exploiting India and Pakistan, both the countries, and that means the entire territory was mindlessly exploited. The economy was shattered. It was in doldrums. There was no employment. There was no government. There was no communal harmony, and all of the above. There was no law and order in the country. So these two countries, they had to start from the scratch. It was very difficult. Even you can take it not from the zero, even from the negative. First of all, these two countries had to correct all these problems, had to solve all these problems, and then to focus on the economic situations, then to focus on law and order, create a government, draft a constitution. So all these things were the challenges. So do you think that these two big nations like India and Pakistan, they had to face so many challenges when they were beginning a new life? How difficult it would have been for the princely states to start it from the scratch, because they had no money, they were not financially stable. It was not difficult, it was very difficult. In fact, it was not possible for these states to feed their population, because they had no money, they had no means for generating employment, they had no external connections, they had no communications, they had no defense, they had no proper defense of their own. Even if some country would have attacked them in that situation, they would have lost it completely. So that was the issue, that somebody it was very difficult for the princely states to decide upon that whether we can become independent or not. So this option was just given, but it was practically not possible. They had to somehow associate themselves with either of the countries. So you can take out two options. One was to stay with India, the other was to go with Pakistan. But surprisingly, that out of 553 princely states, one of the figures that is put forth by Lakshmikant, it says that there were around 552 princely states. 552 princely states. Out of 552 princely states, 549, they chose to stay with India. They chose to stay with India. Which were the rest three who did not choose to stay with India? They wanted to go with Pakistan. One was Hyderabad, the other was Junagadh, and the third one was Kashmir, Jammu and Kashmir. What was the situation with Hyderabad? Hyderabad was it was a completely Muslim state ruled over by the Usmania and the Nizam, and the ruler was Muslim, the population was Muslim. So they, not surprisingly, they chose to go with Pakistan. Junagadh, people were Hindu, but the king was Muslim. So they said, no, we chose to go with Pakistan. The case with Jammu and Kashmir was typical in the sense that the population was Muslim, and the Maharaja was Hindu, Maharaja Hari Singh. So it was very difficult. Now the Constituent Assembly makers, the Constituent Assembly, this Indian National Congress, they very wisely dealt with the situation. They said that these three princely states who have chosen to go with Pakistan are of three different nature: Hyderabad, Junagadh, and Kashmir. All the three states are very different from each other, and then they need different treatments. Hyderabad is a purely Muslim state. The population is Muslim. The ruler is Muslim. So we don't need to talk. Just send the military. So it was annexed by India through military occupation. Then Junagadh में उन्होंने कहा जो population है that is predominantly Hindu. So if we go for a plebiscite, a referendum, then they are definitely going to win. And exactly that happened, that a referendum was conducted in Junagadh and the population voted to stay with India. The Junagadh came by means of referendum. Kashmir's issue was very, very typical of its kind, because Kashmir, a very beautiful state on this planet, perhaps the most beautiful place ever. So Jammu and Kashmir became a piece of cake which was wanted by Pakistan, which was wanted by India, which was wanted by China, and which was wanted by Kashmiris themselves to have it. It became a piece of cake for all of the people. So because Pakistan had started attacking, it was very pertinent for the constituent assemblies to take cognizance of the issue right away. So the the population was going out of control. So they very wisely structured a mechanism. They structured a mechanism to associate Kashmir in some way with India and give it a special status. In what sense? That this Kashmir was accorded a state, an associate state of India, the status of an associate state, granting it a special status under Article 370. और उसमें ये बात रखी गई कि कश्मीर अपने सिर्फ 3 मसले जो नेशनल इंपॉर्टेंस के हैं वो इंडिया को सरेंडर करेगा। बाकी चीजें जितनी भी हैं हिंदुस्तान की, कश्मीर की, वो कश्मीर अपने आप खुद देखेगा। वो 3 चीजें कौन सी हैं जो हिंदुस्तान देखेगा? डिफेंस, कम्युनिकेशंस एंड एक्सटर्नल अफेयर्स। The three subjects, Kashmir had submitted 3 subjects to India: defense, external affairs, and communications. They were supposed to be looked after by India. These 3 things of Kashmir were supposed to be looked after by India. And rest of the things like crime, law and order, economics, employment, everything was supposed to be looked after by the Kashmir itself, the Kashmir government itself. And India cannot interfere in any other matter except these 3 unless the Kashmir government consents to, by submitting its one or more of the subjects to India through a presidential notification. That is what Article 370 says. Article 370 says that these 3 things of Kashmir have been submitted to India. Rest, if Kashmir wants to submit any other subject further to India, this will be done only after the consent of the Kashmir government through a presidential notification. The president will then extend the jurisdiction of the Indian government over that particular subject which the Kashmir government is willing to submit to the Indian government. Exactly. Are you getting my point? So this was clearly stated under Article 370 that if any other subject has to be submitted by Kashmir to India, or the Kashmir is willing to submit any other subject to India, then that has to be done with the consent of the Constituent Assembly of Kashmir, which by a wider interpretation means the government of Jammu and Kashmir, the Legislative Assembly of Jammu and Kashmir by a majority had to decide this, that we are submitting, like for example, we are submitting law and order. Just for example, I'm saying that it never submitted its law and order though, but I'm giving you an example. Like for example, if the Kashmir says that we want to submit a law and order to India. So far, India is looking after our 3 important subjects. Like we want to submit law and order. Like law and order will be like, okay, then the Legislative Assembly of the Kashmir will, do it. Legislative Assembly of Kashmir will then do it through a majority, will then pass it through a majority. Then this presidential notification will be issued, and then this particular subject called law and order of Kashmir will be extended to the jurisdiction of the Indian government, Indian territory. So that's how it was supposed to work. What is Article 35A? Article 35A was provided under the Constitution of Jammu and Kashmir. So Kashmir, Kashmir had different constitution. Kashmir had a separate constitution. Kashmir had separate laws. Article 35A said that whatever What were the consequences of Article 370? Like property matters, property of Kashmir solely belongs to the people of Kashmir. No Kashmiri girl could marry a non-Kashmiri boy, otherwise she would lose all her property rights in Kashmir. I mean, these kinds of things were there in under Article 35A, which we will look after in the presentation PDF. Then, Kashmir is going to have a different criminal law. Like we had IPC, Kashmir had RPC, Ranveer Penal Code. It's going to have different property laws. It's going to have a different set of laws for everything. So, Kashmir had many other things in different. So this was the issue. This was the issue. Suddenly, what happened? That it was a temporary provision, though, but in 2019, in 2019, in August 2019, the Narendra Modi-led BJP government, NDA government, surprisingly and suddenly scrapped Article 370 and made Kashmir a union territory of the Republic of India. So that was found to be the biggest controversy. Then there came the lockdowns in Kashmir. There were severe protests. There was net was shut down completely, so that no communication could take place. For people should not resort to violence. These kinds of things happened, and these kinds of things followed. So let us understand now. I'm starting to share the screen. See, what is some of the history behind the conflict and dispute over Kashmir? Prior to British India gaining independence in 1947 and the partitioning of the region into the dominions of India and Pakistan, the state of J&K was one of the 565 princely states that were not under the direct control of the British colonial administration and retained a great degree of autonomy to manage their own affairs, except in the area of defense and foreign relations. The process of partitioning British India was governed by the 1947 Indian Independence Act. Princely states were not directly incorporated in either dominion, and Section 7(1)(b) of the Act provided that suzerainty of His Majesty over these estates had lapsed and its powers had been returned back to them. They were theoretically granted the option to stay independent or accede to either dominion. However, as described in one journal article, without British forces available for their defense, independence was not a real option for the princely states, many of which were quite small. Like I said, I told you in the very beginning of my lecture, that it was not practically feasible for these princely states to become independent somehow, because it was very difficult for these two big nations to start from the scratch. So how it could have been easy for the princely states to become independent and start almost from zero? The states were encouraged by then Viceroy Lord Mountbatten to accede to one dominion or the other, and did so based on their geographical position, religious identity, or other factors. However, after an uprising against the ruler in Punch and an invasion by a Pathan tribal militia from Pakistan, I told you Pakistan had started attacking India. There was a rise of militia in Pathan tribal militia in Pakistan. So Maharaja Singh decided to turn to India for military assistance and executed an instrument of accession to India. So Kashmir came by way of an instrument of accession. Hyderabad came by way of police action or military action. Junagadh came by way of referendum, and Kashmir came by means of instrument of accession. The accession was executed with expectation that a plebiscite or referendum would be conducted to determine the final status of the state. Okay. Okay. So there's a comment. Okay, you should welcome for the comment, and you should thank RostrumLegal for all these sessions, perhaps. And I'm sorry, I'm not able to read some of the names because they are written in some regional language. Okay, then Eventually, regular Pakistani troops became involved and a direct conflict between the two new countries arose until a UN brokered ceasefire was signed on January 1, 1949. See, these are very important nuggets of information. Very important nuggets of information you have to see that regular Pakistani troops became involved and a direct conflict between the two new countries arose until a UN brokered ceasefire was signed on January 1, 1949. Because Pakistan, it was not that Pakistan had stopped after the instrument of accession had signed with India. Pakistan continued to attack this state until this UN brokered. The UN had brokered a ceasefire. See, what is a ceasefire? When you extinguish the fire, that is known as a small extinguisher, is also known as a ceasefire, because जो छोटी मोटी झड़प होती है ना उसको खत्म करने के लिए, that is known as ceasefire. Until a UN brokered ceasefire was signed on January 1, 1949. Later that same year, a ceasefire line was agreed upon. The northern and western part of the former princely states was administered by Pakistan as Azad Kashmir, and the northern areas, now known as Gilgit-Baltistan and the state of J&K, acceded to India. In 1965, Pakistan and India went through a second war over the status of J&K, but by the end of the conflict, the status quo 1949 ceasefire line was maintained. Terms for a plebiscite could not be agreed to by either side, and by 1954, India dropped the option for a plebiscite. Because 1965, very famous Indo-Pak War, and this was over the status of J&K. So this, like, terms for a plebiscite could not be agreed by India, because India rightly understood that a plebiscite won't work. Plebiscite is not the solution, because plebiscite would perhaps gone in favor of Pakistan. And later in the years, during the prime ministership of Dr. Manmohan Singh also, a referendum was conducted, and the separatists, they had influenced the referendum, the results of the referendum, and it came almost in favor of the Pakistan. Some territorial gains in the Kashmir region were made by India in 1971 during the war between the two countries over the secession of East Pakistan, present-day Bangladesh, which ended with the signing of the Shimla Agreement on July 2, 1972. Now, territorial gains हुए कश्मीर रीजन में, जिसको POK के नाम से जाना जाता है, over the secession of East Pakistan. उधर जो है वो लिबरेशन वॉर हुई बांग्लादेश बनने के लिए, और फिर जब शिमला एग्रीमेंट हुआ जुलाई 2, 1972 में, तो वो एंड हुई. The agreement stipulated that the countries are to settle their differences by peaceful means through bilateral negotiations, and prohibited either country from unilaterally altering the situation. Simla agreement में ये कहा गया था कि आप अपने differences, दोनों countries जो हैं अपने अपने differences, वो peaceful negotiations के साथ, bilateral negotiations के साथ establish करेंगे, और कहीं पर भी आप यूनिलेटरल एक्शन नहीं लेंगे. यूनिलेटरल मींस एक तरफा, बायलेटरल मींस दो तरफा. दोनों लोग बैठकर आपस में बातें करेंगे और अपना एक सॉल्यूशन निकाल लेंगे. Moreover, the 1949 ceasefire line became the line of control, a de facto border between the areas controlled by the respective countries. Okay, 1949 में ceasefire line जो थी वो एक line of control बना दी गई थी, और ये de facto है. This is not de jure. De facto and de jure means by law, by reason of law, by virtue of law. De facto means by reason of fact. This is just a factual, this is not recognized by law. This is just a de facto border between the areas controlled by the respective countries. So perhaps you are getting my point. These are all very important nuggets of information you have read. Now, over the years, the region has been embroiled in many border skirmishes. A high altitude war in 1999, known as the Kargil conflict, between the countries and a Pakistan supported insurgency in Jammu and Kashmir. Now, see, whatever disturbances between India and Pakistan have taken place so far, they have been majorly because of the dispute over Jammu and Kashmir. Because the dispute is a very controversial, heated dispute that has reached the United Nations, right within a span of 2 years. So in 1949, unless the United Nations brokered a peace or ceasefire between the two countries, that could not stop. It could not stop. So the violence could not stop. The controversy has not stopped yet. It continues to, and don't know perhaps how long it's going to continue. Because the Pakistan also seems to have, attacked India after the BJP government, scrapped Article 370. So over the years, the region has been embroiled in many border skirmishes. A high altitude war in 1999 known as the Kargil conflict between the countries, and the Pakistan supported insurgency in Jammu and Kashmir that has existed since 1988. Currently, the Indian government asserts that Jammu and Kashmir is an integral part of India and is a matter strictly internal to India, and any dispute with Pakistan should be resolved bilaterally. Pakistan, on the other hand, takes the position that India's recent actions are a violation of UN Security Council resolutions in Kashmir and bilateral Pakistan India agreements such as the 1972 Shimla Agreement and the Lahore Declaration, and wishes to internationalize the dispute in a global forum. See, understand what are the contentions of the two countries. The country says, India says that Jammu and Kashmir is an integral part of India and is a matter strictly internal to India. So that is a matter of sovereignty, India's sovereignty. India has all the right to take its own decisions. All the sovereign, India is a sovereign nation and it has all the rights to, if Kashmir had earlier submitted this, what the India contends that if Kashmir had earlier submitted its one of the three prime issues to India, then why not India should consider Kashmir as its own integral part? So it continues to say that Kashmir is an integral part of India and is a matter strictly internal to India, and any dispute with Pakistan should be resolved bilaterally. Pakistan, on the other hand, takes the position that India's recent actions are a violation of the UN Security Council resolutions on Kashmir and bilateral Pakistan-India agreements such as the 1972 Shimla Agreement. Because the Shimla Agreement, right now, I told you, it was signed on July 2, 1972, and it expressly stipulated that the two countries have to settle their differences by peaceful means through bilateral negotiations and prohibited either country from unilaterally altering the situation. If some country unilaterally tries to alter the situation, then that is going to be a violation of Shimla Agreement, and that's what India did. That's what Pakistan says, that India has violated the 1972 Shimla Agreement and the Lahore Declaration and wishes to internationalize the dispute in a global forum. Pakistan wants to take this issue to the United Nations. Okay, so what was the legal and constitutional status of Kashmir prior to the revocation of Article 370? Article 370 of the Constitution of India is described as a temporary provision that grants the state of Jammu and Kashmir a special autonomous status within the Indian Union. Okay, if you read Article 370, and even after Article 370, the 371, 372, and there are many other articles which have granted special status to many other Indian states, like Andhra Pradesh, like northeastern states, but their special status differs from the special status of Kashmir. Okay, because Kashmir up till now was an associated state, not a full-fledged state. So its situation was completely different. So under Article 371B, the Union Parliament can only make laws for the state in consultation with the government of the state. See, the Union Parliament, we are talking about the Parliament of India, the elected Parliament of India, of the Republic of India. If the Union Parliament wishes to make any law for the state of Jammu and Kashmir, that has to come in consultation with the government of the state. Government of the state means the government of Jammu and Kashmir on certain matters that were specified in the instrument of accession, namely defense, foreign affairs, and communications. I told you in the beginning that Kashmir in 1947 had already submitted three of its important issues, very important issues of national nature or international nature to India. And that if the Union Parliament wishes to make any law regarding these three matters, it has to consult the government of Jammu and Kashmir. Other matters in the legislative subject lists can apply to Jammu and Kashmir only with the concurrence of the government of the state through a presidential order. Only with the concurrence of the government of the state through a presidential order. If that's what I told you, that if Jammu and Kashmir wants to surrender any other legislative subjects apart from these three, because they are already submitted, apart from these three, if Jammu and Kashmir, the state of Jammu and Kashmir wishes to submit any other legislative subject to India, that has to come with the concurrence of the government of the state. First of all, the government of Jammu and Kashmir has to completely agree upon it through a majority decision that we want to submit this particular legislative subject to India. And then a presidential order will follow. The presidential notification will declare that such and such legislative subject for the state of Jammu and Kashmir has from this date, with effect from this date, has been submitted to Indian jurisdiction. That was the procedure that was laid down under Article 370. Now, Article 370, Clause 1, Subclause D, stipulates that other constitutional provisions may be applied to the state from time to time, subject to such modifications or exceptions made by the President of India, also through, stipulates that other constitutional provisions. It's not that the whole full constitution was applicable to the state of Jammu and Kashmir. Other constitutional provisions may be applied to the state from time to time, subject to such modifications or exceptions made by the President of India. ये प्रेसिडेंट ऑफ इंडिया डिटरमिन करेंगे कि कॉन्स्टिट्यूशन के कौन कौन से प्रोविजंस जो हैं वो जम्मू एंड कश्मीर पे अप्लाई होंगे, लेकिन थ्रू अ प्रेसिडेंशियल ऑर्डर, as long as they do not fall within the matters referred to above and except with the concurrence of the state government. And except with the concurrence of the state government. ठीक है, देखिए, अगर कॉन्स्टिट्यूशन ऑफ इंडिया का कोई भी प्रोविजन, if the government is wanting to extend any provision of the constitution to the application for the application in the state of Jammu and Kashmir, then it has to be done through a presidential order. Presidential order means definitely the president does not do anything, he has to act on the aid and advice of the Council of Ministers headed by the Prime Minister. So he does not do anything by himself. So anything that the government wishes or willing to do or is willing to do has to be done through the president. So यहाँ पर भी presidential order निकालेंगे, as long as they do not fall within the matters referred to above and except with the concurrence of the state government. Has to be done with the concurrence of the state government. Okay, यहाँ पर भी state government की concurrence चाहिए. As a result of this status, the state of Jammu and Kashmir enacted its own constitution, which was formally adopted by a constituent assembly on November 17, 1956 and entered into force on January 26, 1957. There is a huge difference between Indian polity and Kashmir's polity. Indian constitution was adopted on 26 November 1949 and it was enforced on 26 January 1950. But Jammu and Kashmir's constitution was adopted on November 17, 1956 and it was enforced on January 26, 1957, almost 6 and 7 years later respectively. 7 years later it was adopted and 7 years later it was enforced. However, the most important part of Article 370 for purposes of recent developments is Article 370 Clause 3, which gives the President of India the power to amend or repeal Article 370 itself through a public notification declaring that this article shall cease to be operative or shall be operative only with such exceptions and modifications provided that the recommendation of the Constituent Assembly of the state is given before the president issues such a notification. See, we are discussing different provisions of Article 370. 370, almost talked about that if the Kashmir wants to extend any or further wants to submit any of its any other legislative subjects apart from the three that have been already submitted since beginning. If the Kashmir wants to submit any other legal subject or legislative subject to the Indian Republic of India, then it has to be done with the concurrence of the government of the state through a presidential order. Then also that if the president of India wants to extend, or the government of India wants to extend any of the provisions of the Constitution of India through Jammu and Kashmir, then it has to be done through a presidential order with the concurrence of the state government. Now, Article 370 Clause 3 says that the President of India has the power to repeal Article 370 because it is a temporary provision and it shall cease to be operative. While he does this, while he revokes it, he has to issue a notification declaring that this article shall cease to be operative and shall be operative only with such exceptions and modifications, provided that the recommendation of the Constituent Assembly of the state is given before the president issues such a notification. But यहाँ पर भी एक stipulation है. वो stipulation ये है कि president अगर notification भी issue करता है, तब भी कॉन्स्टिट्यूएंट असेंबली ऑफ द स्टेट यानी कि गवर्नमेंट ऑफ द स्टेट ऑफ जम्मू एंड कश्मीर की कॉन्करेंस चाहिए, रिकमेंडेशन चाहिए, is given before the president issues such a notification. So I'm reading this again. The most important part of Article 370 for purposes of recent developments is Article 370 Clause 3, which gives the President of India the power to amend or repeal Article 370 itself through a public notification declaring that this article shall cease to be operative or shall be operative only with such exceptions and modifications, provided that the recommendation of the Constituent Assembly of the state is given before the president issues such a notification. Okay, now let us see further. What is the significance of Article 35A? We have heard and learned a lot about Article 35A. What does this Article 35A, what is its significance? Let us see. In July 1952, an agreement was made between the then Prime Minister of India, Jawaharlal Nehru, and the Prime Minister of Jammu and Kashmir, Sheikh Abdullah, which called for India's citizenship law to be made applicable to the state and allowed the state to regulate the rights and privileges of its own permanent residency. This citizenship is in the since the last 2 years became the biggest controversy, because citizenship laws are being amended by this government, which is known as CAA or NRC, the Citizenship Amendment Act, or the National Register of Citizenship. Now देखिए, कश्मीर अपने 3 चीजें सबमिट कर चुका था, बाकी कश्मीर की सारी चीजें अपनी थी, बट 1952 में एक और मसला सामने आया. वो मसला कहां का था? वो था सिटीजनशिप का. कश्मीरियों का आइडेंटिटी कहां से आएगी? वो कश्मीरी होंगे या इंडियन होंगे? ये बहुत बड़ा मसला था. 1952 में एक बहुत टिपिकल एग्रीमेंट हुआ between Prime Minister of India Jawaharlal Nehru and Prime Minister of Jammu and Kashmir Sheikh Abdullah, जहां पर यह बात तय हुई कि इंडिया के सिटीजनशिप लॉ जितने भी हैं वो सब जम्मू एंड कश्मीर के ऊपर एप्लीकेबल होंगे. ठीक है, लेकिन जो भी कश्मीर के रहने वाले हैं, परमानेंट रेसिडेंट्स हैं, उनके राइट्स और प्रिविलेजेस कश्मीर स्टेट खुद देखेगी. The Indian Republic or the Indian government will not have the right to interfere or intervene in the rights and privileges of these residents of the Jammu and Kashmir, albeit or although they are the citizens of India, because the Indian citizen laws are applicable to the state of Jammu and Kashmir. But there is a rider, there is an exception that the state, only the Jammu and Kashmir state, will have the right to regulate the rights and privileges of its own permanent residents. It's not that if the Indian citizen laws are applicable to the state of Jammu and Kashmir, they have all means and rights to interfere in the rights and privileges of the of the people of Jammu and Kashmir, or the residents of Jammu and Kashmir. Sheikh Abdullah made it sure that there should be least intervention of the Indian Union government into the rights and privileges of these people, residents of Jammu and Kashmir. Albeit if they visit any foreign country, they will be known as Indian. So this agreement was codified by the President of India, who issued the Constitution application to Jammu and Kashmir Order 1954, made pursuant to Article 370 Clause 1 of the Constitution, which added Article 35A to the Indian Constitution, allowing the state of Jammu and Kashmir to define permanent residents of the state and certain special rights and privileges attached to such residency, including the power to restrict settlement to the state and acquire immovable property. Now let us read Article 35A. Saving of laws with respect to permanent residents and their rights. Notwithstanding anything contained in this constitution, no existing law in force in the state of Jammu and Kashmir. No existing law in the state of Jammu and Kashmir, and no law hereafter enacted by the legislature of the state, defining the classes of persons who are or shall be permanent residents of the state of Jammu and Kashmir, or B, conferring on such permanent residents any special rights and privileges, or imposing upon other persons any restrictions as respects employment under the state government, acquisition of immovable property in the state, settlement in the state, or right to scholarships and such other forms of aid as the state governments may provide, shall be void on the ground that it is inconsistent with or takes away or abridges any rights conferred on the other citizens of India by any provision of this part. Okay, so this is very clear कि परमानेंट रेसिडेंट्स को और उनके राइट्स को बिल्कुल सेव कर लिया यहां पे, चाहे कॉन्स्टिट्यूशन में कुछ भी लिखा हो, नो एग्जिस्टिंग लॉ इन फोर्स इन द स्टेट ऑफ जम्मू एंड कश्मीर, या कोई भी बाद में बनाया गया कानून जो लेजिस्लेचर ऑफ द स्टेट जो क्लासेस ऑफ पर्संस को डिफाइन कर रहा है एज परमानेंट रेसिडेंट्स ऑफ स्टेट एंड जम्मू एंड कश्मीर, या कन्फर कर रहा है on such permanent residents any special rights and privileges, or imposing upon other persons any restrictions as respects, क्योंकि बहुत सारे restrictions हैं नॉन कश्मीरीज के ऊपर, बहुत सारे restrictions आर्टिकल 35 ने लगा रखे थे. कौन कौन से? एम्प्लॉयमेंट नहीं मिलेगा स्टेट गवर्नमेंट में, इमूवेबल प्रॉपर्टी नहीं खरीद सकते स्टेट में जाके, से वहां जाके स्टेट में सेटल नहीं हो सकते, स्कॉलरशिप्स या कोई भी अदर तरीके की जो पैसे वाली मदद होती है, फाइनेंशियल एड होती है स्टेट गवर्नमेंट से, वो बाकी लोगों को नहीं मिलेगी. तो ये सारे रिस्ट्रिक्शंस थे नॉन कश्मीरीज के लिए 35A में. ठीक है, ये एम्प्लॉयमेंट अंडर द स्टेट गवर्नमेंट हो, एक्विजिशन ऑफ इमूवेबल प्रॉपर्टी इन द स्टेट हो, सेटलमेंट इन द स्टेट हो, राइट टू स्कॉलरशिप्स एंड सच अदर फॉर्म्स ऑफ एड एज द स्टेट गवर्नमेंट प्रोवाइड. ये अगर फ्यूचर में कोई भी राज्य सरकार जम्मू एंड कश्मीर की, कोई भी सरकार जम्मू एंड कश्मीर की जो फ्यूचर में आती है, अगर इन चीजों को ऑल्टर करने की कोशिश करती है, चेंज करने की कोशिश करती है, तो वो बिल्कुल वॉइड होगा, वो नहीं माना जाएगा, वो माननीय नहीं होगा. It will be considered as if no alteration or no change has been made. Shall be void on the ground that it is inconsistent with or takes away or abridges any rights conferred on the other citizens of India by any provision of this part. Okay, the rights and privileges of permanent residents are laid down in Part 3 of Jammu and Kashmir's 1956 of the Constitution. Like we have our own rights and privileges under Part 3 of the Constitution, the Kashmiris also have their rights and privileges under Part 3 of Jammu and Kashmir's 1956 Constitution. Proponents of the article state that it aims to preserve the identity and demographic makeup of the Muslim majority states. Exactly, all the people who advocate a separate state, a separatist status for the state of Jammu and Kashmir, they say that we have to make up, we have to protect the demographic makeup of the Muslim majority state. So these things are necessary in that respect. They say the national governing party, the Bharatiya Janata Party, promised to revoke the article as part of its election campaign and stated that it would fully integrate the state with demographic change seen as a means of ending conflict in the state. The party also believes that the article hampers economic development of the state. So this was included in BJP's manifesto in the 2019 Lok Sabha elections, that once they come to power again, they are definitely going to repeal Article 370 and they are going to make Kashmir a full-fledged Indian state. Because the 370 is one of the biggest hassles so far in the development of the state. That's what the BJP believed. What steps have been taken to revoke Jammu and Kashmir's special status? As I stated earlier, the entirety of Article 370 can be repealed under Article 370 Clause 3, but this requires a recommendation from the Constituent Assembly of Jammu and Kashmir. Earlier also, like I read the very last provision of Article 370 Clause 3. Article 370 Clause 3 says that the President of India has all powers to repeal Article 370 because it came as a temporary provision and it was a temporary provision, but it also required the recommendation from the Constituent Assembly of Jammu and Kashmir. Here, Constituent Assembly of Jammu and Kashmir means the state of Jammu and Kashmir, the government of Jammu and Kashmir. So it could have the government, the union government could have or should have sought certain recommendations from the state of Jammu and Kashmir in order to fulfill the procedure. However, the Constituent Assembly was dissolved on January 25, 1957 without recommending the abrogation of the article. Several decisions by the High Court of Jammu and Kashmir and the Supreme Court of India, including State Bank of India versus Santosh Gupta and another, have held that despite it being referred to as a temporary provision in the marginal note, the article will continue to be in force and has effectively acquired a permanent status in the Constitution. The High Court of Jammu and Kashmir itself has in catena of judgments held that, however, this its name is a temporary provision just for the sake of a name, but it has acquired a permanent status in the Constitution. Now, what happened on August 5, 2019? On August 5, 2019, the President of India issued the Constitution application to Jammu and Kashmir Order 2019. Pursuant to Article 370, Clause 1 of the Constitution of India, constitutional lawyer Gautam Bhatia states that this constitutes the basis for everything that follows. The order stipulates that with the concurrence of the government of state of Jammu and Kashmir, all the provisions of the Constitution as amended from time to time shall apply in relation to the state of Jammu and Kashmir. All the provisions are going to apply to the state of Jammu and Kashmir. Moreover, since the government could not directly rely on Article 370 Clause 3 to abrogate other articles, it sought to use its powers under Article 370 Clause 1 to amend Article 367, the interpretation clause of the Constitution, so that references to government of state of Jammu and Kashmir in Article 370 would be construed as the governor of Jammu and Kashmir, and the expression Constituent Assembly of the state in Article 370 Clause 3 will be read as referring to the current Legislative Assembly of Kashmir. Now, all the things have been changed, all alterations have been made. पूरा कॉन्स्टिट्यूशन लागू होगा अब कश्मीर के ऊपर, और साथ ही साथ इसके साथ साथ कश्मीर के जितने भी अभी तक भारत के संविधान में अमेंडमेंट्स हुए हैं, चेंजेस हुए हैं, 104 अमेंडमेंट्स हो चुके हैं, वो सबके सब भी कश्मीर में अप्लाई होंगे. ओके, सो मोरओवर, since the government could not rely on Article 370 Clause 3 to abrogate other articles, it sought to use its powers under Article 370 Clause 1 to amend Article 367, the interpretation clause of the Constitution, so that references to government of the state of Jammu and Kashmir in Article 370 would be construed as the governor of Jammu and Kashmir, and the expression Constituent Assembly of the state in Article 370 Clause 3 will be read as referring to the current Legislative Assembly of Kashmir. उन्होंने कहा कि ये जो कॉन्स्टिट्यूएंट असेंबली का मतलब है, कॉन्स्टिट्यूएंट असेंबली की रिकमेंडेशन होनी चाहिए, तो कॉन्स्टिट्यूएंट असेंबली तो बहुत पहले डिसॉल्व हो गई 1957 में. कॉन्स्टिट्यूशन बनाया और लागू करने के बाद वो गायब हो गई, वो डिसॉल्व हो गई. तो अब कहां से लाएं कॉन्स्टिट्यूएंट असेंबली ऑफ जम्मू एंड कश्मीर? तो उन्होंने कहा ये इसका मतलब ये है कि कॉन्स्टिट्यूएंट असेंबली सारी उम्र तो बैठी नहीं रहेगी, तो अब इसमें इसका मतलब होता है गवर्नमेंट ऑफ जम्मू एंड कश्मीर. The order also stipulates that it will supersede the Constitution application to Jammu and Kashmir Order 1954, effectively abrogating Article 35A as well. तो इस ऑर्डर के जरिए से 35A को भी एब्रोगेट कर दिया गया. On the same day, India's upper house of parliament, that means Rajya Sabha, passed a statutory resolution recommending that the President of India abrogate most of Article 370 pursuant to Article 370 Clause 3. The next day, on August 6, the President implemented the resolution and revoked Jammu and Kashmir's special status through Presidential Order CO 273, which stated that as of August 6, 2019, all clauses of the said Article 370 shall cease to be operative, and that all provisions of this constitution as amended from time to time without any modifications or exceptions shall apply to the state of Jammu and Kashmir. Okay. During the same period, the Parliament of India also passed the Jammu and Kashmir Reorganization Act 2019. It passed the upper house on August 5 and the lower house the next day and received presidential assent on August 19, 2019. Okay. Now, these are some political developments which I'm just reading. The goal of this legislation, this is one of the important points. The goal of this legislation was to reorganize Jammu and Kashmir from being one state, autonomous or non-autonomous, into two union territories, units of governments that are always under direct national control. One union territory, which would include Kashmir Valley, would have a legislature, whereas other, Ladakh, a mountainous region bordering China that has also seen some border skirmishes, would be without a legislature. So basically there is an addition of two union territories. One is the Kashmir Valley itself with the legislature. Now there are three union territories with a legislature, with the Vidhan Sabha. One is Delhi, one is Puducherry, the other is Puducherry, and the third one is the Kashmir Valley. And also the Ladakh is going to be, because Ladakh is a mountainous region that borders with China, which has also seen some border skirmishes. So it is important to take it into directly under the national control, but it's going to be without a legislature. So basically there is an addition of two union territories. One is Kashmir, the other is Ladakh. The government claims that the revocation was carried out for the economic development and growth of the state, aiming to avert unrest in the state and prevent protests. The government subsequently cut landline, mobile and internet communications, and political leaders and activists were arrested under the Jammu and Kashmir Public Safety Act. Reuters reported that according to a government report dated September 6, more than 3,800 people were arrested, though about 2,600 have since been released. Curfews and lockdowns were imposed. Reports from late August and early September indicate that India has eased some of the restrictions, including those on daytime movement, and some landline phone connections have been restored. So are there any legal challenges being considered by India's court? Yes, there are some legal challenges also. The revocation of Article 370 faces a number of legal challenges according to lawyers and legal experts. First, there is a doubt as to whether the concurrence of the government of the state of Jammu and Kashmir has been received, because no such concurrence seems to have been obtained by the union government. So first of all, the first flaw that seems to exist is that the concurrence of the state of Jammu and Kashmir was not sought by the union government. For the past year, the state has been under direct presidential rule and under Article 356 of the Constitution after the BJP withdrew from an alliance, because there was a coalition government between PDF and BJP, and later they could not continue together. So this all broke down. The coalition broke down, and Kashmir came under the president's rule. From an alliance with the regional party, and the governor of the state dissolved the state assembly. According to one lawyer, the governor is a representative of the central government, the president, like the president. In effect, therefore, the presidential order 272 amounts to the central government taking its own consent to amend the constitution. तो इसका मतलब ये हुआ कि वहां पर प्रेसिडेंट्स का रूल का क्या मतलब है, गवर्नर बैठा हुआ है, तो जो गवर्नर है उसी से पूछ लो, यानी कि खुद ही काम करने के लिए खुद ही से पूछना, ये वो वाली बात हो गई. Another objection is that Article 370 Clause 1, subclause C, this article shall apply in relation to the state, prevents that the president from using his power of amendment in the constitution as applicable to J&K to amend Article 370 itself, even if it is done indirectly. The normal amendment procedure under Article 368 would have to be utilized. दूसरी बात यह है कि जो 368 में नॉर्मल अमेंडमेंट प्रोसीजर है वो अप्लाई नहीं किया गया, 370 का इस्तेमाल किया गया. जब अमेंडमेंट के लिए 368 है तो 370 का इस्तेमाल क्यों किया गया? ठीक है. अब इसमें सुप्रीम कोर्ट कुछ न्यूज रिपोर्ट्स के अकॉर्डिंग कुछ 14-15 पब्लिक इंटरेस्ट लिटिगेशन ऑलरेडी जम्मू एंड कश्मीर पे सुन रहा है और चैलेंज कर रहे हैं कि एब्रोगेशन जो है वो गलत तरीके से हुआ है और जितने भी रिस्ट्रिक्शंस और कम्युनिकेशंस के ऊपर, मूवमेंट्स के ऊपर, कम्युनिकेशंस के ऊपर कश्मीर वैली में रिस्ट्रिक्शंस लगाए गए हैं वो हटा दिए जाएं। और एक 5 मेंबर बेंच कॉन्स्टिट्यूट की थी सुप्रीम कोर्ट ने अगस्त 28 2019 को, ताकि इन सारे पॉइंट्स को और मसलों को सुना जा सके। ओके, नाउ on September 16, 2019, according to news reports, the Supreme Court agreed to accept the petition filed by J&K People's Conference, a state political party challenging the president's rule imposed in the state and abrogation of provisions of Article 370, but declined to entertain any new petitions challenging the order related to Article 370. The Chief Justice of the Supreme Court is also reported to have stated that we direct Jammu and Kashmir to make the very best endeavor to make sure normal life returns after a panel of 3 judges heard several petitions relating to the state. And on October 1, 2019, it was reported that the court started hearings on the above matter, but granted the central government 28 days to reply to all Jammu and Kashmir related petitions. So, I mean, all all these things simply means that Supreme Court also seems reluctant on hearing these petitions, because Supreme Court, very interestingly heard the petitions and the grievances of the people of Kashmir relating to the restrictions imposed on the movements and communications of the people of Kashmir. In fact, it went to the same extent of saying that internet, right to have access to the internet or communications, is a fundamental right. You cannot deny these basic rights to the people of Kashmir. So that was earlier said. But so far as the issue relating to the abrogation of Article 370 is concerned, it is not being taken up seriously so far. Now let us see, once this corona crisis ends up, let us see how the Supreme Court has to take up this issue further. Okay, if you have any questions, please, I'm willing to take the questions now. There is a question from Shweta Varyani. Now it will be difficult for Supreme Court to reimpose 370 in Jammu and Kashmir. Nothing is difficult for the judiciary. Judiciary will do what it deems fit and appropriate. If the Supreme Court finds, if the Supreme Court finds any procedural flaw in the abrogation of Article 370, it is definitely going to hold it as unconstitutional and perhaps will direct the union government to reimpose Article 370 in the state of Jammu and Kashmir. Now, there is a question that the decision by government is good or bad for the country. See, this is a political question which needs a political answer, definitely. It might be good in the interest of the development and economic growth of the state, and it was actually needed, because 370 was acting as one of the hassles in the development and economic growth of the country. This is just one version. But on the other hand also, The people of Kashmir since 1947 had been reluctant to, uh, you know, to come with India. So we have to see both the things. At one point of time, you can say that it is good for the development and economic growth for the country. On the other hand, you can also say that there is a huge violation of the rights of the people of Kashmir, because they had been willing to stay the way they are staying since so long. Okay. Okay, so perhaps no more questions, and I am ending the broadcast now. Good evening. Bye bye. Welcome.